Well, today was an arraignment date. My client was originally scheduled for arraignment on June 21st. And over our objection 3 times, he was not arraigned because there was issues about a lawyer for the co-defendant, Robert Pape. We filed a writ of habeas corpus. We filed motions to dismiss this case on 2 different grounds, and we filed a motion to reveal what they're referring to as a citizen informant. All of those motions were scheduled to be heard today. However, because Judge Benjamini has sent us to another judge, Judge Evans here, those will be scheduled to be heard on this Friday. So this Friday we'll go through a scheduling process. And hopefully then we will accelerate this. My client is a decorated military veteran with 5 deployments to the Middle East. He shouldn't be here. He's not guilty of the charges that have been brought against him, and he should be released as soon as possible.
And can we just kind of clarify just a few things that happened inside the
Sure.
courtroom today, just with the changing of judges? Any idea maybe why that happened? I know you filed a 170.6.
Well, what happened is Judge Benjamini is in what's called a calendar court. He's going to assign this case to a judge for what they call all purposes, meaning you don't come back to the calendar court, you go to that judge, and all your motions, all your pretrial issues, everything is taken care of in that court, including the preliminary hearing. Eventually then, there's a trial, if that happens, and that will be in front of that judge who's assigned for all purposes as well. So today, Judge Benjamini assigned us to one judge. That judge was not acceptable to one of the parties, and so the party, that would be me, filed what they call a 170.6. That's just a document that says we would rather not go to this judge, and we have the right to do that one time in any case. So we filed that, and that's why we were sent to Judge Evans.
Okay, and so would you be interested in explaining why you didn't want the other judge?
No, really, it isn't a matter of the judge is not qualified or anything like that. That's just sometimes you have preferences or you have thoughts about how a case is going to unfold, and you make decisions based on that. But there's no personal animosity. There's no issue of competence or anything like that. It's just something that you do sometimes strategically in a case.
Gotcha. And so I believe they were talking about 3,700 pages of discovery. Can you kind of elaborate on what that might be?
Well, there are hundreds of pages from a grand jury indictment that took place about 2.5 years ago. There's about 3,700 pages we already have from the last time that they filed this case and ultimately decided they didn't have enough evidence to go forward and dismissed it in October of 2014. What they've done is reorganize all of the discovery and add what they say are new and different reports about some of the issues in the case and handed it to us on a disc. So we've got about 8 notebooks in bait stamp order, they call it, indexed and ready to go for trial. Now we have to go back, tear that apart, put it in a new bait stamped order, re-index the file. So it's not overwhelming to us because we've already been through this once. For somebody who's just walking into this case, just reviewing the discovery is probably a 2-month process.
Oh my gosh. And so speaking about you doing this now a second time, does this make this more difficult for you as an attorney or a little bit easier?
I don't know if it's any more difficult or less difficult. A triple homicide is a very challenging case. When you've got a client who's innocent, it's even more challenging because we can't come in and try and work a deal out with the DA. It's essentially an all or nothing situation. One of the motions that we filed was to dismiss this case because it's already been charged twice, once as an indictment and once as a complaint that was dismissed. In California, Penal Code Section 825 says you can't charge somebody more than twice for the same crime. So that's the initial motion we want to have heard. If that motion is denied, we will be in the appellate courts immediately arguing that this court made a mistake. We also have a motion called a Jones motion, a pre-complaint delay motion, that our client has been prejudiced because this is now 10 years old and witnesses are gone, they're deceased, they're unavailable, memories fade, and it's just not fundamentally fair to charge somebody 10 years after an event. We've got another motion to reveal the identity of what they call a citizen informant. I think I know who this person is, and we'll wait to see when we get the motion granted and we get the discovery that's based on this person, if it makes any difference at all in this case.
That was going to be my last question, was anything more about that informant?
They essentially went over all the DNA evidence, they rehashed it. They went over all the cell tower evidence and rehashed it, nothing new there. A little bit of a different analysis, but frankly, neither one's very impressive in my opinion. If the confidential informant, the citizen informant is the person I think it is, It's really not going to be terribly compelling or impressive to hear what this person has to say. And so we're back again with a decorated military veteran who spent 7 months in jail before it was dismissed the last time, and has now spent a month in jail and just got arraigned today. And it's infuriating to think that a person that has given literally his blood and his time and effort to the country is being treated in this way. Many people walk into court and there's a rule that you're supposed to have an arraignment within 48 hours. We're talking about more like 30 days with objections made to continuing the arraignment 3 times and denied. Sadly, our only remedy is to ask for an OR release, and frankly that was denied the last time. So it's a very difficult, challenging case. And it's an extreme case in the sense that there's no middle ground. It's all or nothing.
And just last question, we waived the 10 days, and you're hoping to get that preliminary hearing set before the 60 days?
Yeah, you have a right to a prelim within 10 days of your arraignment and no more than 60 days of your arraignment. Sometimes for scheduling purposes, you can't get it scheduled within 10 days. There will be no waiver of the 60-day right. This case will have a preliminary hearing or it will be dismissed before 60 days pass from today.